Hello, my name is Tin. Today, Josh and I will introduce you to the case Edwards v. Aguillard from 1987, which was brought up to the Supreme Court because of the Establishment Clause. We will tell you more about the parties involved in the case itself, more in detail, more legal issues about the case, and how the court ruled in this case. Furthermore, we will also state our own opinions and what we think would be the right way.
Hello, my name is Josh Mutiku, and I am a business student at the Rinker School of Business studying business administration, primarily finance, and I have massive interest in private finance and deal sourcing and things in that general area, as well as really the invention of new things and supporting that through finance. And so today we're going to be going over Edwards versus Aguillard. That is a mouthful of a last name, as Tin already stated. And I will be going over the parties involved. So let's get started. To begin with, Edwards, or Edwin Edwards, is the defendant, and Edwin Edwards was the governor in Louisiana in the early 80s, and I can't remember exactly how long he was in office, but he was a relatively popular governor, and he was a strong Christian, as you can imagine, Louisiana being kind of in that Bible Belt. And so he strongly believed that the Christian faith should also be implemented in different ways, or I should say, it should be a part of, not completely excluded in schools. And so he signed a bill, and he wasn't the only one who helped form this bill, but he helped sign in the bill, the Balanced Treatment for Creation Science and Evolution Science Act. And this act basically meant that creation science had to be taught alongside of evolution. He was, as I already stated, a strong Christian, and he believed that this act was not a violation of what we'll later cover, the Establishment Clause, separation of church and state, but was merely just a way of informing and bringing into the classroom multiple opinions. The plaintiff, Don Aguillard, was a high school teacher who was very, very involved in the society, and he was rather outraged at Edwards for putting forth this bill. And in 1986, I believe, is when he brought it to court. He wanted to strike it down. He found that it was unconstitutional, and he did not want to teach creation science, and the fact that the bill, the Balanced Treatment for Creation Science, it mandated that you had to implement creation science into the curriculum if you were going to teach evolution, really angered him.
So, what are the details to this case? Our defendant, Governor Edwards, passed a law in Louisiana that schools are required to teach equally as much creationism as they do evolution. It was called the Balanced Treatment of Creation Science and Evolution Science. But a high school teacher in Louisiana, Don Aguillard, or plaintiff, found that this new law was unconstitutional because it would promote a certain religious belief. And in our First Amendment, state and religion should stay separated from each other. So now the argument in this case is, does the state want to promote a certain religion by implying this balanced treatment? And also, how does it affect academic freedom?
So the Establishment Clause is relatively easy to understand. It's held within the First Amendment, and all it basically means is that you have to have separation of church and state. This is done by putting the law in question up to the Lemon Test. And the Lemon Test covers three different main items: secular purpose, primary effect, and excessive entanglement. If the law does not have a primarily secular purpose, so non-religious point, it can be struck down. If the primary effect of the law is to inhibit religion or directly advance religion, the law would be struck down. As you can see, it would go against secular purpose. And then excessive entanglement, this one is marginally more confusing, but the law must not foster excessive government entanglement. And I believe that this would be really down to what the judge feels as entanglement or not entanglement. A great example of this, and it started much earlier, but the biology teacher, Susan Epperson, challenged a similar law, or I believe it was a lot more restrictive, where they could not even teach the theory of evolution, and this was in 1966. And so there was already a precedent when this case came up in 1986.
So what are further legal issues related to religious freedom in this case? The first one, the Establishment Clause, Josh already mentioned, including the Lemon Test. But also the government endorsing religion is one of the primary issues in this case, because creationism is believed by Christianity, so it has a religious background to it, but the state argues that it's still a science, and why they believe that they're not endorsing a religion, but rather a different side of science than evolution is showing. Furthermore, it is arguable if it's a secular or a religious purpose of this law, which the state argues that they imply this law to give students the academic freedom to hear multiple alternatives about a possible historic event and how everything happened that we have now? Or is it to promote a certain religious belief, which is not allowed by the First Amendment, where we have to part state from religion? Also, we found this picture from Joseph Ferdinand Kepler, who envisioned what a world would look like if science and religion were one.
Decision time. So, out of the 9 Supreme Court justices, only 2 supported Edwards in the end. The rest went along with Aguillard. This set a huge precedent in the education world, especially in public school, meaning that you could not teach creationist principles or theory in the education system, or specifically public schools. They struck down the law, the balanced treatment for creation science and evolution science, and they found it unconstitutional under the First Amendment, as it did not stand up to the Lemon test. I do find, though, coming into the opinion, that Scalia was especially interesting case, and his comments really did resound with me, as he found that the science being taught along the evolution theory was not in fact a direct what's the right word? I would say a direct support of creationist viewpoints. He viewed it as a ability for people to have a broader concept of both different opinions. And I personally agree with this statement. In several of my readings, I saw that it is very likely that if this same case would have come down today, that there would be more agreement with Antonin Scalia. And I find that very interesting, that even in the last going on 40 years now, that there has been more of a realignment with Scalia's principles. And I personally stand in that realm where I do not believe that it directly went against the First Amendment.
I agree with Josh and also with Justice Scalia, where I believe that students should hear different alternatives. And also I believe that creation science has scientific facts to it, and it's not just a religious thing. But even if it is, I think that students should hear both the evolution and the creation, and they should be able to choose what they believe in themselves, and not be withheld from one just because it has some religious background to it. But I also think that it's important that if it is taught in school, that both have to be taught neutral and not endorsing creation science and putting evolution science down, but rather stating both to students in a neutral way where they can decide for themselves what they believe in and what they think was our history and how we ended up here. Also, further, we wanted to include something that we learned from this case, because I think that's very important. For example, I didn't know that the First Amendment stated that religion and state have to be separated, since I'm a non-American. I think that's very interesting that that is part of the law, and Josh will also state his point of what he learned.
Thank you so much for your attention. I hope this has been as informative and interesting as I found it.